Hello. Hello, everybody. Come on in, please grab a seat so we can jump right into our next panel session. All right, welcome everybody. Welcome back. Really looking forward to this next panel session, as I know many of you also are. Getting into the nitty-gritty of AI, law, legality, copyrightability, and all of that. So I will turn it over to Gabi Kochlani to kick us off for this panel.
Hello. Welcome to AI, legality, and copyrightability. We have so much to cover on this incredible topic and a lot of amazing panelists. We're going to just jump right into it because we want to just answer all the questions about AI. Starting with, we'd like to start with a brief rundown of the various types of AI in the music business, just to give a clear understanding of the different types: generative, non-generative. Let's start with that.
I can start. Hi, everyone. Good morning. I'm Sunray. Thank you so much for having us. I'm from the NMPA. So as Gabi said, you know, the dividing line in our view in many ways is between generative and other forms of AI. AI isn't really anything new. It's been around for decades. You can think of a lot of technologies that we already engage with as AI, right? The predictive text mechanism in our phones is a more primitive form of AI. In music production, you know, even auto-tune, Melodyne, these can be considered forms of AI. On the non-generative side, there is, there's object recognition technology that can help you like sift through large databases of samples, sync library, libraries for sync uses and the like. And I think there are a lot of really great applications for that technology. But then when you get to the generative side of things, what we're talking about is the creation or the mimicry, essentially, of human creative expression. And that can be developed in a number of ways, and I'm sure we'll get into some of the exciting and not so exciting applications of that today. But generative AI is what everyone is probably here to discuss and hear us talk about. So,
thank you, Eric. Love to get into how is AI currently being used in music creation. I think that's a very important topic for everybody. And what are the primary copyright challenges that arise from the usage?
Sure. My name is John LaCroix. I'm here with Bulletproof Bear. We're from a library, and like these guys who are licensed attorneys in this field. And so that's our perspective. I'd say some of the challenges that we're facing right now as copyright holders is determining which side of the fence you're going to be on, and what the rights are that are going to be associated with generative AI, and how you want to participate on that. So I think right now, AI can't hold a copyright, can't have any authorship. If it can't hold authorship, if it's purely generative with no human authorship, it effectively falls in the public domain. And we also have to determine, as for human input, if there's going to be a collaboration or some kind of AI with human input, what those rights are going to look like, and how to move forward, how to navigate what the path looks like forward. And I think it's important to know what your options are, and what the law is currently, and what the future looks like moving forward.
Yeah. I think some of the copyright challenges, relate to where you are using AI to assist you in creating, a musical work. To what extent can you claim the copyright? To what extent is the copyright created or generated by the AI software? The office, the Copyright Office, has given us some guidance in this area. As John has stated, it has to be human authorship, and human authorship is really, the elements of, literary or musical or artistic expression have been created by the human being and not by, the computer. And I think in a lot of ways this comes down to also choices, who's making the choices, who is generating things based on choices. Because the office has said, it's okay to use technology to assist you in creating a work of human authorship. You can use a DAW, you can use a sequencer, you can use an arpeggiator. There are tools that people have been using for years, and as long as you're using that and making choices based on what is generated for you, like for example, a chord generator saying, here are 5 good chords that might sound good with this. You pick a chord, that's human expression, and that should be copyrightable. And I'll get to later a little bit things around registration because that's an important issue as well, but those are some of the copyright challenges.
In addition to what Frank said on copyrightability, I think it helps to divide all of the various AI copyright issues into a few different buckets. On the one hand, one thing that we at the NMPA have been really focused on is what we would call training-related concerns. A lot of these generative AI systems develop their musical know-how, so to speak, by ingesting large quantities of oftentimes copyright-protected works. So there's a whole body of litigation now on these issues, right? What does it mean to train an AI model using copyrighted works? Then there are output-related concerns, right? What happens if an AI system generates something that is substantially similar to a pre-existing work? There's also, of course, the copyrightability of it all. But then another sort of output-related concern that I'm sure many of you have on your minds today and would love to address as the day goes on is, what does it ultimately mean to compete with these systems as humans? And that's more of a philosophical question, and I don't know that there's an easy answer to it. But if it helps break down these issues into those buckets, that's how we often tend to think about it.
Thank you. So AI music is not currently copyrightable. Should AI-generated music be eligible for copyright at all?
Maybe I can chip in. Hi everyone, Johnny Phelan here from ICMP, music publishers worldwide. We support NMPA and other MPAs around the world. Just how we view this is, well, the first question we always ask is what is AI and what is AI music? We see 5 areas. One is the classic sort of B2B and B2C areas, as Eric mentioned, have been used across the industry in many different forms. Nothing new, nothing novel, no copyright questions. Second area then is how people are using AI in the creative processes to assist songwriting and the creation of music. And that speaks to that copyrightability issues. Different answers around the world. We looked at 76 different national copyright legislation around the world. For sins in a former life, that's what we have to do. And the good news is that basically across all of that different copyright law reform, our conclusion was, not to oversimplify, that exclusive rights and copyright regimes around the world are pretty well set up to cater for all of the different forms of AI music. The third, fourth, and fifth areas, as Eric has mentioned as well too here, we separate out these uses of AI into the, I hesitate to use the word ingestion and training because AI is not a sentient thing and we shouldn't anthropomorphize what is crude scraping of the internet, but access, training, and generation. Those 3 areas we separate out. Why? Because companies like Google, Microsoft, OpenAI, Midjourney, they're also commercially and legally, and indeed geographically, separating out those areas. So they all throw up different questions as what to do. Just on the AI music, I think these words, AI music, it's really important what do we mean by that. So for us, AI music is purely algorithmic audio, machine-generated works, call it what you want. And that is the very serious risk to the licensed digital music market for obvious competition reasons. So we've been working on a strategy which is basically protection first and then potentially pivot to profit as long as songwriters agree to that licensing scheme. But what we need to tackle first and foremost is the greatest IP theft in human history. AI companies and big tech companies, we have looked into all of the evidence and data in detail of how they're training their models. Let's not let the sort of, the sort of verbiage and vocabulary of these companies to entice VC investment, let's not succumb to that. They are scraping the internet. It's nothing more than that. And if I take a track from YouTube today and put it in my pocket, I'm a stream ripper. These companies are stream ripping on steroids. So we need to stop that. And we need to stop the taking of songwriters and creators' content, and then we can address issues such as AI music, the machine-generated works, which in China, it is possible to copyright that based upon the degree of input by the software engineer of the AI system. And in South Korea, they've said that basically, again, it depends on the degree of human threshold. So in one case in Midjourney, the entering of 200 verbal prompts into that Midjourney system was sufficient editorial or human input to create a potential copyrightability in the eventual output. But what we're seeing broadly in the marketplace is that OpenAI, Suno, Udio, all of the household names that you know and are aware of, are flat out infringing our industry's rights. Not some of it, not a lot of it, all of it, and that's what needs to stop.
Thank you. Currently, how do the PROs and CMOs handle royalties for AI-generated compositions? Are they able to distinguish who do they consider the author at this point?
I can speak to how the MLC is handling it currently. Last year, the MLC sought guidance from the Copyright Office on what to do with what they suspected was, the proliferation of AI-generated musical works on DSPs. And this was, of course, shortly after the Copyright Office had issued its registration guidance that Frank mentioned before. And what they said to the MLC, the Copyright Office, was, if you suspect or you know that something was AI-generated, set it aside, investigate, and then only once you discover that it is an actually human-authored work or protectable by copyright, then you can issue the royalties. But I think there's a big question mark there, is like, how do you detect this? Stream manipulation, streaming fraud are things that have existed for a long time, and there's some overlap in how we can detect generative AI works on DSPs via those now more, I guess you can call them traditional methods, investigative methods, but it's a big question mark, and you might have noticed in the news recently there was a guy who criminal charges were actually brought against him for devising this scheme where he used AI to generate thousands of works, get them up on DSPs, and for a while at least, evade detection and earn quite a bit of money. So it's a big question, it's a big concern, but that's how the MLC is handling it.
Yeah, I think to sort of follow up on that, I think the Copyright Office's guidance to the MLC, gave an example, which was an example, if you see, one author, generating, thousands of works in a day or 2 days, that might raise a red flag that you should, further investigate. And I think, Eric is right. The issue of AI generated works appearing on, streaming services is largely, a fraud issue, right? Because if a stream falls in the forest and nobody listens to it, right, what happens, right? Nobody gets paid anything for that. But, a lot of this, a lot of the AI generated, purely AI generated works are tied to and linked to people using bots and bot forms and things of that nature. And as you know, because the royalties are payable out of a pool, every fake stream, every stream of a work that really wouldn't have otherwise gotten played takes away a royalty from, or diminishes or reduces the royalty to human authors. So, that obviously is a problem.
With that being said, could AI help in identifying and preventing copyright infringement?
Yeah, I mean, our industry is using AI to find AI and copyright enforcing content, If that's not an Orbis definition, I'm not sure what is. But yeah, absolutely. Again, it's really important to define what we're talking about here. What is AI music? So take, for example, I think probably the most beautiful symbiosis of creativity and technology was the famous Randy Travis example last year, where Randy, having suffered a debilitating stroke in 2013 and can no longer speak, never mind sing, is writing his own lyrics, and then his right holder partners are able to train on his old sound recordings to create a generative AI output of what is his voice, call it a sound-alike if you like, and matching that to his newly handwritten lyrics in order to create a wonderful new output, which is entirely copyrightable because people are recording the music behind that. He's writing the lyrics, the graphic rights are involved, the mechanical rights, the sync rights, the performance rights, and all of the different suite of rights which would normally flow into digital music. They're all there because AI is just being used as a tool to supplement that process. And that's obviously very distinguishable from the pure, crude, simple, fraudulent, machine-generated audio, which we see flooding the marketplace. And Spotify and DSPs we're working with to make sure that not only comes down, but also many of our members are changing their deals to reflect human-centric deals and royalty flowing back to human-centric created content. We do not want to see royalties flowing to machine-generated works, and this is the biggest issue that we currently face. And when we're talking about anything to do with generative AI, the most important question that every AI company must answer is, where are you getting your data from? Answer that question first, and then we can have a conversation about whether that's fraud or whether there's something there to license, and it must come back to the composer's permission, if it's the latter.
Can I jump in on that for a second? Yeah. The where are you getting your data from point is really important, right? Because, transparency is a huge issue and a huge problem. Because, I think it's a little bit ironic that a lot of AI companies refuse to say, what data they're training their model on, yet they're claiming that their use in training is a fair use. How could it be a fair use if you're not even willing to tell us what the use is, right? And so there's a lot of, proposed legislation, around transparency in order to make sure that, the AI modelers are keeping track of what they're using, because it's also a problem in bringing an enforcement action. Because if you don't know, you can't prove what is in the model, you have a trouble bringing a lawsuit in the first place to even get discovery. So I think it's important to, follow these laws, follow these regulations that are hopefully going to be enacted to make sure that, copyright owners can see and potentially get through a subpoena or otherwise prior to bringing a lawsuit, get the data to know that their works have been used in training.
Thank you. I think the most important issue is AI is affecting the money in everybody's pocket, taking away jobs. Most importantly, how is the rise of AI-generated music affecting the size and distribution of all the royalty pools?
I will just say, just some sheer numbers, right? Like, we know that about 120,000 works are being added to Spotify every day. That comes to about 43 million works a year. I think Boomi, since its brief existence, has generated some 13 million works, which is about, is it 13 million? Somewhere around that, which is, a very large percentage of the world's recorded music in just a couple of years. So certainly that is, it's a matter of scale, and, again, it's also a matter of fraud, and it's, a matter of trying to find a human-authored work becomes a needle in a haystack.
I think a lot of it, it remains to be seen still, because it is still early days in many ways. I mean, the technology has advanced so much. I hesitate to say early days, but it really does remain to be seen exactly what the extent of that diminishment is. But it does go back to the issue, like the gentleman I mentioned before, who was indicted, for having, racked up $10 million off of his AI scheme here. There are fraudsters out there, and we know that it poses a threat. So being vigilant and knowing that it is an issue is incredibly important.
I think these are all really valid concerns and problems. I think my biggest concern is the world's biggest companies are scraping everything and training. And if you look at Google and how it wants to deploy DreamTrack across the UGC marketplace, a marketplace that we've fought so hard for the last 8-9 years through Article 17 and other initiatives to license, get proper transparency on and proper distributions on, that clearly shows a vulnerability if we enable Google and Microsoft and OpenAI and Apple, who's now got the same problems as OpenAI has, if we allow them to deploy generative AI onto these digital marketplaces and platforms, that presents a clear and present risk. The good news is that we don't need new copyright law to tackle these. Obviously, the state initiatives here in the US have been very helpful to tackle specific issues, but copyright is copyright is copyright, and exclusive rights are exclusive rights. And tech companies can change the name of an exception all they want, from TDM to fair use or computational data assessment. It doesn't apply. There is no legal, moral, or indeed ethical excuse for the commercial use of protected music without a license. And the good news is in the EU AI Act, there's a whole series of provisions which will help not just restate that basic principle and norm, but build on a whole series of enforcement actions against companies like Google and OpenAI who are doing this. and provide the ability for transparency, and that transparency will have global effect. So if you're scraping and training in Singapore because you think it's got a low threshold of copyright protection, and you're doing your training in London, you're doing your generation in West Coast America, as soon as you deploy that generation anywhere onto the internet, which is available in Europe, which is pretty much everything, you're liable all the way back to Singapore. That's a transformative thing, and these big tech companies are very nervous, and so they should be, about these provisions which are coming in the EU AI Act.
One more thing on fair use in the U.S., because a lot of these tech companies are claiming that what they're doing by ingesting these works and making copies, there has been some goalpost shifting, right? Initially, they said no copies were being made, and then now they say, oh, well, copies are being made, but it's a fair use. It's like, okay, well, what's the next step in this process? But important thing to know about fair use from a legal perspective is that it's a fact-intensive inquiry, and every instance is case by case, right? There's no world in which there is a categorical training as fair use ruling. And there are like at least 24 lawsuits right now that are pending in the courts at various procedural stages that are dealing with these very issues, and I'm hopeful to see them come to the right conclusion. But it's important to know that, fair use, there's no categorical fair use exception. In addition to that, the notion that the use is transformative, right, which is, of course, an allusion to one of the sub-factors, I guess you could say, of the fair use analysis. Transformative use, is it something transformative? Well, that's just like a judicial gloss on the first fair use factor. I'm sorry if I'm getting a little bit too weedy here on the legal stuff, but I just think it's important to know that there are a lot of euphemisms that these developers engage in: transformative use, fair use, taking things that are publicly available. Well, it's just publicly available, so why shouldn't I be able to use it? But as we were discussing backstage before the panel, music for the better part of 2 decades now has all been publicly available, and that is just an outgrowth of the business compromise, the business solution that was arrived at after the last transformative technological revolution, which was peer-to-peer file sharing, right? So here we are, the last innovation that almost ruined the music industry has laid the groundwork, so to speak, for the next technological innovation that poses a threat to the music industry. So I think it's important to just recognize a lot of these euphemisms that the AI companies are trafficking in.
Yeah, just briefly on fair use. I think you have to disaggregate sort of the training from the variable output, right? Because a lot of the AI companies say, well, if something is produced that is substantially and similar to the work that it trains upon, that is that might be an infringement, but that really maybe is the fault of the user. It's not my fault, and my AI is not designed to do that. But I think as John is pointing out, the reproduction and the use of the works in training to create new works that substitute for the works upon which they are trained, I think is not, under Warhol or under other fair use tests, really a fair use. And the other thing they're saying is that, well, there's no copies being made, or the copies are just of transitory duration because we convert them into tokens. But again, the tokens are still copies, right? There's ones and zeros. And I think you have to also keep track of the model that sits in the middle between the training and the output, is also potentially infringing. It could be a derivative work. It could be an unlawful reproduction. So I think it's easy for the services to say, well, the training that you don't see and you can't really get behind is a fair use. And also, if something comes out that's substantially similar, that's really not the way this is designed. But the whole model is commercial, and it's designed to create commercial substitutional works.
Thank you. When it comes to sync, which is a very important part of the business, what are companies, music studios, doing to enforce policies with AI music for film, TV, commercial licensing?
I will say that we were approached with this probably 2 years ago, I think, before it was a more common discussion, and that was for training. So we've been approached by a few different companies on this. I haven't seen any companies fully dive in for generative AI. It sounds good. Everyone's kind of chasing it. I think you guys made the comment about the venture funding for it, but with the brands that we deal with on the daily, no one's going towards generative. There's and part of it I think is a little bit of an education, letting them know like, hey, are you guys sure you want to take that risk? So for all of us, if you have clients that are kind of willing to go down that road, I think part of our job is to educate them on the risks. Generative AI is there's a little bit of an X factor with it. And I had a meeting on a Friday with an agency, and they said, they're like, we don't use any generative AI because it's not brand safe, right? We've all had like a generative AI image that's got like 3 eyeballs and like a hand wrapped around, and so it's just like kind of this X factor. You don't know exactly what you're going to get. And on the music side, there's like the composition part, but then there's also like the blending, possibly, of the masters, right? So it's just like you never really know what you're going to get. So we haven't really run into that. I think people are looking at it for like maybe lower level, like UGC or social media, but I haven't run into anything yet. Definitely no big brands, no big campaigns. We haven't run into anybody like even considering it because it's just not, it's not safe. That said, we haven't also seen, there's a couple other things. I think it depends on how the rights organizations respond to this, and I'm not just talking about the performing rights, but like performance of the master, whether you're a featured performer or a non-featured performer, the mechanical side, depends how they respond to this. It also depends on if you have any insurance policy, like whether they're gonna defend a claim on that, and I think that's yet to be determined. I think, but all these things for your clients, and you'll have to decide who wants to participate, or if you want to add some human interaction with this generative AI part, that's another conversation. But I think it's good to inform your clients of all the spectrum of the rabbit holes basically that you can fall into.
Anybody else?
I mean, I think one thing worth noting on this subject is that for all the discussion about generative AI and the models that Google's putting out, and Meta, and OpenAI, and Suno, you do all the rest, there hasn't really been a widespread adoption of these tools yet. I mean, I'm sure folks have engaged with them. You've seen some of the outputs, and there may be use cases, on a case-by-case basis, but I don't think there's really been like the kind of widespread adoption that you would think there has been, given how much publicity this issue has gotten. OpenAI, which is probably the most recognizable brand in all of AI at this point, is hemorrhaging money. It's not profitable. That doesn't mean that it isn't going to have a long-term trajectory and it's going to be around for a long time, but it is not a profitable company. Their enterprise customers are not even coming close to keeping it afloat. So as much as you might like to log in and play around with ChatGPT from time to time, it really hasn't, the use case hasn't really gotten there yet. So a lot remains to be seen. And again, I hate to put it this way, but it is early days for a lot of this tech.
And just maybe on your question on the excuse me, the PRO CMO point, I mean, we work with them all around the world, and obviously this is a question, and hopefully keeping those CMOs and PROs in prudent check, not to let the horse bolt on these questions. Everyone has been quite disciplined on that issue, and I think we really should be and continue to be. But this is not beyond the wit of the industry to do. I mean, take the example of Dave Gilmore and the Orb. Showing my taste and age here, but they've got an amazing generative AI model whereby on an app you can go through all of the repertoire of those incredible bodies of work, and you can merge it and create new generative aspects and so on and so forth. That's a fully licensed and perfectly functional and legitimate way to engage with generative AI, and all of the rights are being recognized all the way back to the the good old graphic right, which is actually doing much of the heavy lifting on catching copyright infringement for these generative AI companies. but you've got the graphic right, the mechanical right, the performance right, and the sync right is being actualized there because people have full ownership of the content. Where we need to be very wary is someone providing either a collective or direct model to enable the scraping of the internet, and that's not happening. And to Eric's point as well, too, these companies are hemorrhaging money. Stability AI, likewise, the quality is not good. It will improve, but can it really get good without using commercial music? We think the reason why they're using commercial music, and we've looked into the model training of Meta, Google, OpenAI, and what we found is revelatory. And they're using the world's music, and they're doing that for clear reasons. One is to try and make it good, and that's what why we're focused on enforcement first, about ending that.
Thank you. I'd love to get into some of the positive trends that you're seeing with AI in music production, and what could we expect to see?
Well, I think if we use Frank had mentioned it, you know, if we use it as a tool, and I'm kind of like broad scoping this, you know, like instead of like, you know, guitar amps, we have plugins now, we have auto-tune, we have backgrounds now. If we plug in the chord, if you have your melody, it can create those harmonies for you. Also, for me personally, you know, I can't sing, but now I could plug my voice into this, you know, something, and now I can sound like, you know, like I can. You know, and I think if we use it as a tool, we also have like mastering tools, mixing tools, and I think if we use it as a tool, I think that could be, you know, obviously it is useful, and you know, we're not going to be able to can't fight innovation and technology. You know, you have to go with it, but I feel strongly, and this is my personal opinion, you know, that these should just be tools. You know, they shouldn't be creating the complete output for you. And that's just me more as like a creative itself. So.
I think there's one or two examples out there. I've mentioned the Randy example and how people can use it as a tool to, you know, create these amazing little ways in which music creation on a copyrighted basis can be done. If anyone has seen the Sphere out in Vegas, I hate talking about this because I was supposed to go there to see the U2 show, and it was the day before the European Parliament voted on the EU Act, so I had to cancel. But the show is extraordinary, and it's a generative AI visual imagery, all done with Ez Devlin, the famous visual artist, and it creates extraordinary generative AI imagery, licensed, people are getting paid, and so on and so forth. But, you know, complicated is complicated, and I think that basically, you know, AI to do meaningful things will have to go through much more banal usages, such as, you know, collective licensing administration, chasing, you know, metadata around the world on a marketplace that we have now of more than 3,000 different stream video on demand services around the world. You know, AI can play a real use there. It can, you know, be used like Ableton or Pro Tools was, you know, 15, 20 years ago when they arrived on the marketplace in terms of helping creators, you know, create a body of work. But it's as important to point out what it should not be, and it should not be, say, using the ability to use robots to machine crawl the internet for your commercial profiteering on the basis of infringement.
I mean, also opportunities is in the title of this platform, and obviously it's a big, huge licensing opportunity. It should be licensed. It needs to be licensed, and you know, the training needs to be licensed. And I think, you know, one of the arguments again that AI modelers and AI companies make is that it's not possible to license it all. I can't possibly license it all, so therefore I should have a right to just use it. And first of all, there's nothing in the law that says, you know, theft by reason of necessity is okay. And in fact, you know, the Kinko's Books case, you know, rejected that flat out and said, you know, just because people want and need course packs and would really be helpful to educators doesn't mean you can make them, right? And so I think but again, in the music industry, right, we have in place like a very complex and very effective licensing model. I mean, we've been able to license, you know, hundreds of thousands of recordings and musical compositions, you know, to all sorts of platforms. So this is just another platform and another opportunity to license, and I'm hopeful that, you know, that may come about creating new revenue streams for the music industry.
Sounds like, Frank, you've been getting the same two complicated arguments that we've been getting for 12 years on UGC and YouTube, you know. And like, joking aside, it's the same old washed out arguments about exceptions applying. They said it about net neutrality, they said it about, you know, data protection, they said it about, you know, safe harbor, said about DMCA. These exceptions do not apply, full stop. And is it too complicated to do? On YouTube today, which is one UGC service of thousands, there are now 14 billion videos on YouTube. There's 170 million music tracks which ICMP members represent, and every single one of those, of course, is ISWC codes, IPI codes, ISRC codes. It's all doable. It's a question of will.
Yeah, and one last thing on you know, the positives. I want to touch on a few quick things that everyone mentioned. On the licensing side and the potential new revenue streams, there's a phenomenon in machine learning called model collapse, where when an AI retrains on its own outputs, do I want to use this phrase? It's like AI inbreeding almost, you know, pretty much like it just it dumps the system down to the point where it cannot function as intended. And I think that should be something that rights holders are empowered by. Like, there is an opportunity here to put your guard up and say, okay, if you want to continue developing these tools, come to the table. Because I think that rights holders probably would be willing to entertain a discussion about participating in the development of these tools, but that, you know, that permission hasn't been asked yet. So really, consent, credit, compensation, those are necessary elements, preconditions going forward. And then on, you know, for creators, like, I'm a lifelong musician, and some of the, like, the stem separation tools that are out there, like, that stuff is fascinating. I could have only dreamt of these kinds of tools when I was learning to play and trying to prepare for gigs. And I guess that maybe that's why I'm a little bit bitter now that I'm a lawyer and no longer a performing musician. But no, I mean, I think it's fantastic, you know, the stem separation to remix and remaster recordings that, you know, maybe were made before the advent of multi-track recording, you know, digital recording. I think it's all exciting, but again, credit, compensation, and consent.
Just one more thing on that. That's the key thing, right, is proper licensing, but I also see a world similar to what's going on with some of the 11 Labs things, where voiceover or someone's likeness, publicity rights are being licensed for advertising. So there could potentially be a marketplace where those things are properly licensed. That could be, you know, musicians, vocals, other things as well. There could be an opportunity there.
Yeah, and I will say in that area, the name, image, likeness area, that's the area that I think is most likely to yield new legislation. I mean, John was saying, you know, the Copyright Act that we have in the U.S., you know, really covers a lot of this stuff. It doesn't really effectively cover name, image, likeness. We have, you know, a panoply of state laws that are somewhat inconsistent. And I think, you know, there's a couple of bills in Congress that are, you know, pushing to sort of create a federal right in that. And I think, I suspect that's probably going to happen and somewhere down the road.
I think maybe on a positive note as well too, I think I said this last year actually, and I'll say it again, which is that, you know, take the gaming industry, you know, in 20 short years, that's now got an industry today which is driving more revenue back to creators than the movie, TV and radio business in the US today. That's an extraordinary thing. And when you think about what's actually happening at practical level, this room knows better than anybody, is about the sheer money flowing into composition there, the employment of orchestras to record these incredible symphonic scores. And people are doing that because gaming needs quality music, because users love quality music. Do we really want a future of audible algorithms? I'm not so sure.
Thank you. How are, just back on the positivity tip, like, how are copyright laws continuing to evolve positively? And what can you expect to see for AI-generated music for human creators in a positive way?
Well, I think something that Frank and Johnny have just said, they really aren't evolving, so to speak, because I think the copyright laws, at least in the US, were drafted to be flexible enough to adapt to new technologies. And like I said before, for all the litigation that's out there dealing with this issue of whether training is fair use or not, I mean, that matter hasn't been resolved by the courts yet. And we maintain our position that we've held all along, which is that that is a use that requires a license. Similar to the output-related concern that I mentioned at the beginning of the panel, if an AI system generates something that is infringing another work, well, we know how to deal with that because that's just infringement. So we're not advocating for new laws with respect, a change to the copyright laws for those kinds of uses. And on the name, image, and likeness front, I mean, I think that isn't really, on the publishing side, an issue that we feel as acutely as our friends on the label side, although we're incredibly supportive of them getting the protections that they need to that end. But this may be a good time to raise the point that the Copyright Office, as the culmination of its notice of inquiry from last year into this issue of artificial intelligence, it sought feedback from stakeholders across the board on these issues. We submitted comments. I'm sure everyone here, perhaps many of you submitted comments as well. And the Copyright Office has just started issuing its reports detailing its findings on these issues. And the first report that it issued was on the name, image, and likeness question, protections for name, image, and likeness. And what it concluded, and it recommended to Congress, was an urgent need for legislation in that space. So, as Frank said, I anticipate that being the way that the law will most soon evolve.
Yeah, they got, I think, over 10,000 comments, and they have said publicly that they did not use AI to examine them, which I think was good. I think, also, two more areas. I think, copyright is effective and broad enough to handle a lot of these issues. But I did mention transparency earlier, and I think that's a weakness because, again, you need to bring a lawsuit to get discovery, and it's hard to bring a lawsuit because you need to know what work has been used by the training, and you don't really know that now because they're kind of keep hiding the ball on that. So I think that's an area for legislation, and has been proposed legislation in that area. I would also say the Copyright Office issued some really useful guidance on registration. And registration is very important. I think it's very important for rights owners because if somebody takes your work or tries to use your work, you're best able to enforce it if you registered it with the Copyright Office. And they've issued some guidance on that about disclaiming parts of the work that may be AI generated or solely AI generated. And I think it's important to keep that in mind because you don't want to just register your copyright, and if there's some AI in there that should have been disclaimed, you might lose your registration, or if there was a court case, you might not be able to your registration might be challenged. So, for example, you might have all heard about the Zaria of the Dawn case, right? In that case, the comic author used images that were generated by an AI, but she added text, bubble captions, and she selected an arrangement of text. And originally, they denied the application for the registration, but then they issued a corrected one where she got the right to claim selection and arrangement. She got the right to claim, the bubble text, the text of her comic. And if that hadn't happened and she had sued, if somebody had taken her comic text, she might have lost. So I think, keeping in mind registration is important, and the Copyright Office has issued some useful guidance in that area.
Just maybe on the copyright law reform to point out that maybe three sort of headlines. As I mentioned earlier, copyright laws in most places are pretty well set to deal with most of these uses, so we don't want governments generally to
Yeah, oh, that thing's back. It's back on.
Johnny?
check.
Someone really doesn't want to hear my headlines. All right, so copyright law and AI. Basically, we don't want governments to do much apart from in those specific cases, as Eric's mentioned, on more on the mass recording side for sound alikes. That being said, politicians being politicians, there are now 91 different forms of AI proposals on the table around the world. So we got to try and manage that and input to that. The second thing I would say is that where it can be useful to bring in new laws is maybe on the enforcement side. We don't need to change and redefine copyright, but as per the EU AI Act, better enforcement if you're an AI company infringing copyright law is a useful thing. So specifically within the EU AI Act is a clarification. You need the prior authorization from rights holders for scraping, training, and generation. And if you don't do that, you've then got obligations to meet. You will then be sanctioned if you don't meet those obligations. And those obligations include a publicly available, what's called a sufficiently detailed summary of your training data. So as of 6 months' time, Microsoft, OpenAI, Stability, Google, Meta, you name it, they will have to publicly declare what it is they're training upon. And that's what they're most nervous about, and so be it. Also, further to that, they need to retain detailed technical documentation as to what they're training upon. Now, when we look at their machine learning data sets, some of these data sets, I mean, if you take something like a Tab9 company, I mean, they've got about 14 different model training data sets. Each model training data set is more than 600,000 lines of data, mostly scraped from YouTube at a per URL level. So they have this data, this detailed technical documentation. They don't want to reveal it, but under the legislation, they will have to retain that and declare that data. And if you don't do that, you'll then be subject to breach of the legislation. So again, really useful tools to bring in better enforcement against AI companies who are breaking laws of all kinds. And I do want to emphasize that global effect of the EU AI Act that I mentioned earlier. The third area I just wanted to mention as well too is avoiding exceptions. This is a big risk. So a lot of governments around the world are kind of falling for the argumentation that in order to attract foreign direct investment from AI companies, you need to bring in exceptions and lower copyright standards in order to do that. Doesn't stack up legally nor commercially. If you take a country like Singapore, which is currently taking that approach, or Hong Kong likewise, we've looked at all the data around that, and we're recommending very strongly to those governments and to many other Far East Asian governments to not take that approach and to avoid copyright exceptions for the benefit of AI companies. The ironic thing is not only would that drive a coaching horses through the creative sectors, but we've looked at the terms and conditions of every single one of these tech companies and AI companies, and buried in there, what does it say for Google and Microsoft and OpenAI and Facebook? It says, you shall not copy, scrape, modify, train, access, machine learn, transform, reproduce, access, etc., without the prior written consent of us. So that's the way it should be. I agree with Google there, but we demand precisely the same thing, and there should be no broadening of copyright exceptions to enable these companies to get ahead and compete unfairly.
And one thing on prior authorization, you know, there's a big question right now between opt-in versus opt-out. At NMPA, at least, we are staunchly in the opt-in camp. I think that is, first of all, consistent with copyright law. Copyright law is an opt-in regime. You know, you need affirmative consent for use of your works. It's not the kind of thing where I'm going to use your works unless you opt out. No, that's not how it works. And it's also impractical. Opt-out is also impractical in the sense that the diffuse nature of the internet is such that if I could say, no, you can't take my work from here, but you can just go over there and get it. So what good is that, right? So opt-in, opt-in, opt-in.
Sorry to hog the mic, but just on the specific point, could not agree more. We're not chasing this rabbit around the room. We've set up a website called rightsandai.com. It's available in 9 different languages. It's not just a PR stunt, it's legally operational, so it's a rights reservation demanding the prior authorization from rights holders. And it's operational at a technical level because it's got a .csv file with all of the business information of every company who has signed up to that. We don't need to reserve our rights in this area, but it's just a way of restating from creators and from rights holders that these companies need to take prior authorization before they can proceed further. So I would encourage everyone here, if you're not signed up to rightsandai.com, to hop on over there and check it out in Japanese or Arabic as suits you best.
And we don't need any more compulsory licenses.
Thanks. I think we have time for a couple more questions, then we'll get into Q&A. What resources can people follow and to keep up with everything going on with AI and legislation?
Come work with us.
Yeah, I definitely encourage you to check out all of our submissions to the Copyright Office for more detail on our perspectives on these and more issues. If anyone here is a publisher, songwriter, composer, I would encourage you to get in touch with the NMPA, consider becoming a member. Come talk to me after the panel, or my colleague Stephanie, who's our VP of membership, will be here all week. She'll be happy to talk to you about some of the benefits that come with membership at NMPA. Among them, our updates on AI.
Yeah, and obviously there are a whole bunch of lawsuits that you could follow. I think the most interesting ones, for the music industry, obviously, are the Anthropic case brought by the publishers regarding lyrics, the Suno and Udio cases brought by the recording industry, and I think the OpenAI Times case is going to be a real bellwether case. So those are three kind of cases you can watch to see these fair use arguments play out and some of these other arguments play out.
And on that front as well too, the Guangzhou Internet Court in China has had the world's first ever generative AI copyright infringement case already. So believe it or not, China has got the best AI guidelines in the world, all the way to obliging AI companies to tag at a metadata level, per work level, what's going into the input. That gives you a whole traceable metadata link all the way through to the generative output. And as I say, China's already doubled down by issuing court cases against AI companies for copyright infringement. So credit where credit's due.
Last question.
Really quick, just for everyone too, because I'm not an attorney, I get really nerdy and I follow all these cases. I look up the filings. If there's a docket on these, I'll check it out. Also, I think it's really important for all of us to read the terms of service on some of these generative AI companies. They're publicly available. You can download them and look them out. They get into the weeds a lot, but the things that you'll see on some of these things is that these generative AI companies are basically indemnifying themselves from their users, and they're not warranting and representing full control of the copyright, all the forms of the copyright within the composition and master. And that should tell you something. Should be that there's an issue there. So I would highly encourage everyone to read those. And also in cases also where there may be joint generative AI with human input, is to read further and see, if your contribution of this human input is eventually, going to harm you in the future. So you can kind of read between the lines on certain things, but I would highly recommend you to read those.
Last question, then we can do a couple Q&As. Do you guys use AI for anything? And if so, what is it? Do you use AI for anything?
I make all my beats with AI.
No.
I mean, just to the extent you use Logic Pro or something like that,
Yeah, I mean, I've mentioned that there are some exciting emerging things within the industry for AI to, facilitate licensing administration and, all the kind of might perceivably be banal stuff, which is precisely what AI is supposed to do, deliver massive at-scale readability of data sets and the interchange of those data sets. So there are some uses, I think, which we'll start to see increases in, and I mentioned the copyright enforcement side as well, too. But for me, the term itself, AI, it's kind of not very helpful. It's an umbrella term, which is just too broad. Somebody once said, AI is everything that doesn't work yet, the rest is just software. And I think there's a kernel of truth in that.
Awesome. Questions? Someone with a mic running around?
Thank you for doing this panel. I've been dealing with AI. I've been a composer since '74 and an engineer and a music producer. So I dived into AI, and the question is, because I've been using it, how much, and you touched on it, I'm also a lyricist, and I've inputted my lyrics and my music into one of the websites. How much of that is mine and how much is copyrightable? And you just touched on when I put a track in, it duplicates the track, pretty much. And now does it use that to learn as well? So these are two questions. But the first one is how much of it is mine? My lyrics, and then I'll make a choice of how those lyrics are used by doing up to 10 to 12 different versions, and I'll go, I like that version. And I might even change the lyrics because I start to hear how it's responding, and I go, that lyric doesn't work. And I'll rewrite the lyric. I don't use AI for lyric, although I could, and I have in the past, but I don't anymore. So how much of it is mine?
This I feel is the next issue, right? And the question is like the combo of like AI but human input. And so I guess this would be a question for you guys. Is there like guidance on what the minimum human threshold is for copyright protection?
Yeah, I think I kind of touched upon it earlier. Basically, you know, if you have a work that combines your own original creative expression, literary, artistic, musical, obviously the lyrics fit into that definition, right? So the lyrics are yours, they're copyrightable. If you were to put the lyrics into an AI platform and have it generate music, you did nothing to generate the music yourself, you just put a prompt in or put the lyrics in, and the music is generated. If you were to register that with the Copyright Office, you'd have to disclaim the music. You'd say, I didn't write the music is AI generated. Now, there's the other question whether that AI generated music infringes some other sound recording or musical work, which is an issue that's going to be determined, I guess, by a lot of these cases. But in terms of registering the copyright, you would own the lyrics, you could claim the lyrics, but you could not claim the sound recording or the musical work. Yeah, it gets tricky, right? I think, you know, if you're taking the music and you're rewriting it, rearranging it, making it your own, then it likely is your own, but then it's covered by sort of general principles of copyright that are outside the AI universe, right? Like, if you took any piece of music that you heard on the radio and you're like, I like that, but I'm going to rewrite it and make it my own, could you do that? Is there an infringement? Is it substantially similar? Those usual legal principles would apply in the same context.
There's actually a test case that similar to what you're describing, where a guy generated an image with the Midjourney platform, and I think he used something like 600 prompts to realize his vision. And then he took that, and then he made some edits in Photoshop afterwards. And the Copyright Office, based on its current guidance, said it wouldn't register the work except for the modest edits that he made in Photoshop afterwards. I don't know if that's where the law is going to remain. I mean, the next report that the Copyright Office is going to be issuing in its AI study is on this very issue, so I imagine they'll expound a bit more on the guidance they gave last year. But it's worth looking into some of the test cases that the Copyright Office's review board has been wrestling with for more on that.
And just a very quick chip in before, because I think his next question, further to what Frank said about the originality aspect of kind of arranging works, don't forget as well too, what you're putting into the model training, it might be a copy of a score, is an infringement without a license. Be wary of that.
Hi, thank you very much for the panel. It was incredible. My name is Apoena. I live in New York. I write music for film and TV. If we look at AI as simply technology, and if we compare it, for example, with the evolution of video games and how when they released the PlayStation 1, it looked incredible, but now we look back, it looks kind of like, wow, right? And same thing with auto-tune, how like now most producers can recognize but when it was out the first time, nobody could tell if it was tuned in the studio or not. Do you think that, as AI develops and is going to become even more, it's going to fool us in an increasing level, do you think that, are we going to be able to look back at 2024, 2025 and say, oh, okay, that was obviously created by AI, that's not human, and they're gonna just discard that or just frame it in a way or another.
Have you tried Suno or Udio? It's pretty impressive.
Yeah, and it's just going to get better and better. But for me, that's not the most pertinent question. The question is how are you getting there? And basically, that means where are you getting your data from? And everybody in this room encountering any AI company anywhere shouldn't move past that first question is, what are you training your data on? And until they answer that question, there's no conversation really to be had, because I don't think it can get good without using quality data. And so, you know, that will be the question in 5 years' time, in 10 years' time, in 15 years' time. And models should not be trained without prior authorization. So will there be MIDI-like or synth-like, you know, kind of souped-up versions of the old bossa nova button used to have on a Casio in the 80s? Yeah, and that will get better, but that's in one bucket, and that's not illegal.
Yeah, I think there's no question that the tech is so good, and it's going to get, you know, it's exponentially better. The question for me is the legal aspect. I've had our partners call and they're like, John, have you heard this thing? It's so good, and they're so freaked out. And I was like, yeah, just cool, you know, just calm down for a second, because it's going to come down to a legal and copyright question, and there's a lot of pieces that are kind of strung together. Again, it's like, you know, insurance, the CMOs, and then there's, you know, the law itself, and, you know, as case law, you know, comes into effect, how it's all going to come together. But yeah, the tech's definitely, you can't stop it. It's going to get there for sure.
Right. There's a reason it's good, right? It's good because it takes good music and uses it by humans.
I think that's our time. Thank you guys so much. Let's give a round of applause. Frank, Eric, Johnny, John, thanks so much.
Thank you.
You gotta talk to them. Ask them your question.